Hi, everybody. It's Cathleen Scott, and welcome to the Cathleen Scott podcast. Today's episode is going to be in depth, but it's going to be so important. I hope you join me all the way to the end. We're going to talk about the First Amendment and what's happening in Texas and Louisiana with the 10 Commandments being required to be placed in public classrooms. So is this legal? Is it not legal? Is it constitutional? We're going to dive into those issues today. So please stay with me. So let's do a little background. In 2025, Texas signed into law what was known as Senate Bill 10. This bill actually required that the state of Texas required in all school district public schools the 10 Commandments would hang in the classroom. What happened next? The law went into effect September 1. There's numerous individuals and parties who filed an effort to stop this bill coming into law, and that happened. And then the issue went before the Texas Appellate Court. This is interesting because Texas is sort of right now into a kind of a posture where they're doing a lot of things to try to adapt religion into schools. For example, the school board is actually approving content that contains Bible verses. And that's one thing happening. Another thing that's happened, and dating all the way back to 2005 in a case known as Orden versus Perry, the Supreme Court ruled the 10 Commandments in a monument could exist at the Texas state capitol grounds, that it was historic, not religious, and therefore did not violate any of the religious prohibitions in the Constitution. So let's talk about what happened. So we said this house in Texas that this bill became law requiring the 10 Commandments to be the law. And then a priest and a rabbi and a dozen other organizations like the ACLU filed against the independent school district to have the court enjoin or stop the enforcement of that law. And that case is known as Nathan versus Alamo. And in that case, the court did find that requiring the 10 Commandments to be in the classroom actually violated the First Amendment. It violated both the Establishment Clause and the Free Exercise Clause. So I always keep with me my handy-dandy copy of the United States Constitution and the First Amendment. And so for those who just need a quick little refresher on what the Establishment Clause is, let me just read it to you, because I think it's fun to remember these things. It says, Congress shall make no law respecting establishment of religion or prohibiting the free exercise thereof. And that's what it's meant by the Establishment Clause and the Free Exercise Clause. So the district court granted the injunction and denied the motion to dismiss. And so the law was stopped. Of course, that went up to the next court. But I want to talk a little bit about why the court at the district level found that this law did in fact violate the Constitution. And what it found was that it was using what's called the Protestant version of the 10 Commandments. It wasn't a neutral document. It wasn't a historical document. It had added this sectarian text to it, and that made it religious as opposed to making it entirely historical. The government and the judge, rather, in a very lengthy opinion, started to describe the danger of when a government puts its thumb on the scale of one religion versus another religion. And it gave an example of imagining that if a majority Muslim city required certain Quranic verses to be played in the classroom or to be posted in the classroom, how that might be offensive to some, right? And so why the court reminds us in a very eloquent opinion that majorities change, but the protections granted by the Constitution, they don't change. While we the people rule by majority, the Bill of Rights protects the minority Christians and the Hamtramck and those 33% of Texans who do not adhere to any specific Christian doctrine. That's at the order at page 4. The second basis that the trial court enjoined and found this law to be unconstitutional was based on the way that it was contrary to what the framers insisted on, the separation of church and state. And the court notes a few things. And it goes on to cite religious conflicts that have existed since the beginning of time. It talks about Christians versus Christian violence in Europe. It talks about Catholic versus Protestant bloodshed in Ireland. It talks about the persecution of Jews, Puritan witch trials, Mormon prosecution, and even the Sunni and Shiite conflict. These are things the court reminds us and how it's so important that the government not put its thumb on one particular religious belief over another, because doing so historically has led to coercion, exclusion, violence. And in this particular part of the order, the judge cites to Sonny and Cher to underscore the persistence of religious conflict and says the beat goes on, and that's at page 8. So the court emphasized that the founders flatly rejected government-controlled religion, and for this reason, we must have a complete separation of church and state doctrine. The judge cites the United States former President Grant, and he writes, quote, "Keep the church and state forever separate." And contrast that with Billy Graham's Majorian argument for why school and prayer should exist. Those of you who are my age might remember that, noting that the Bill of Rights protects the minority, not the majority. And that's the importance. So in conclusion, Senate Bill 10 was struck down. The court found that the law's purpose was entirely religional, not historic, not educational. And because the display was mandatory in the classrooms, then it couldn't be placed in the classrooms without students feeling pressure. So the court found, as it must find when it grants an injunction, that there was a likelihood of success, meaning there was a likelihood that this particular requirement would violate the Free Establishment Clause that I just read to you. In finding that what the court said is that the state was inculcating a specific religious doctrine and noted that children can be cruel. And children whose family reject the posted religious doctrine may actually feel pressure or indoctrinated. And that can cause a harm. And the balance here, they said, the balance here was clearly in favor of the family and favored the plaintiffs because the state could teach civic values without religious text. The public interest favored protecting religious liberty and pluralism, and even suggested alternatives that Texas could use instead of the Ten Commandments, and cited to the 5 moral precepts of Buddhism, and also cited to all I really needed to learn I learned in kindergarten, and cited the famous author Robert Fulghum. So this court, as if the judge was writing, understanding that this issue was ultimately going to be before the Supreme Court. But in a very passionate and lengthy order, the court goes on to use musical lyrics, biblical references, historical examples of religious prosecution, and even closes with a Hitler-era imagery to understand the importance of why we can never let government-endorsed religion rule the day and why government neutrality has to exist. So this is happening in Texas. Along the same timeline, another law is happening in Louisiana, very similar, requiring the 10 Commandments. Now, that law got all the way through, and the court said it wasn't ripe because it actually hadn't happened, meaning that the commandments hadn't actually been hung on the wall yet. And so now we have the Fifth Circuit, which is the Court of Appeal for both Louisiana and Texas, weighing in on whether these two statutes are required and whether they're constitutional and whether they can withstand constitutional muster. And so what the court said is essentially this. It looked at some key precedents. It looked at, what is the basis of the Establishment Clause and why it doesn't, in an unbelievable opinion, the Fifth Circuit basically said, no, requiring the 10 Commandments in every public classroom does not violate either the Free Establishment Clause, and it doesn't violate the Free Exercise Clause. And here's what the court said, that it's entirely historical. The 10 Commandments are entirely historical, and there's no possibility of feeling indoctrinated or feeling pressured or coerced if these are hanging in the classroom. So the court vacated the injunction, which is the stay, and allowed this law to take place, which it will, unless the Supreme Court unwinds it. And so let's take a look at what they said. So now the court had to go through kind of a pretzel twisting view of religious doctrine and the prior history of when something does violate the First Amendment. Historically, the Supreme Court has used a test known as the Lemon Test, but this court, which is interesting because only the Supreme Court can undo the Supreme Court precedent, but the Fifth Circuit and basically felt that it was saying that lemon was no longer the law and it would be a change and move away from that doctrine. That's pretty remarkable. What the court said is that the 10 Commandments are historical hallmarks of an establishment. And it goes on to cite that government has control over the church doctrine. Governments are clergy. It doesn't require compulsory church attendance. It doesn't require religious taxes. The use of churches for civil functions. All of these things are missing from the bill, and therefore it's not enough to be considered a violation of the First Amendment. And it said that this particular bill in Texas had none of those features and therefore would pass constitutional muster. The court emphasized there was no one was required to worship a particular religion or affirm or recite the 10 Commandments. There was no penalties if you disengaged or disagreed with that particular fundament. No church was funded or controlled by the 10 Commandments. Teachers weren't required to teach the importance of them. And a poster on the wall, the court said, is not a founding era establishment and therefore does not equal coercion. It rejected the plaintiff's arguments that the mere fact of the display that it uses religious language, so that doesn't convert anybody into a call to prayer. It says that coercion under the Establishment Clause has to rise to compelling religious worship, and that the Ten Commandments did not do that. If you had to summarize this opinion in a short sentence, what you would say is the court found that being exposed to religious beliefs does not create a substantial burden and therefore is not a constitutional violation. A shocking departure of decades-long Supreme Court and other appellate courts' opinion. You might remember a similar issue from a few years back when the Texas court was grappling with the rights of LGBTQ communities and those teachers that were putting up classroom signs that said, "Everybody's welcome here," and rainbow flags. That was found to have a coercive effect. This is an ironic contradiction to those. So apparently the court is now outcome-oriented. In other words, they are thinking about the outcome they want and willing to twist decades long of constitutional precedent to get there. More on that to come. So the bottom line is that the Fifth Circuit Court of Appeal upheld this Texas requirement. They basically said that the Lemon Court, which is a Supreme Court doctrine, is dead. Again, you have the Fifth Circuit essentially overruling the Supreme Court. They must have high confidence that the Supreme Court is going to go their way. The new test now for whether or not something is a violation of the First Amendment is no longer whether it's coercive, apparently. Under this test, the new test is whether it's historical in its background. So the question we need to ask ourselves is putting up the Ten Commandments historical test, or is it religious content? And that's something that the Supreme Court's going to have to grapple with. I'm sure everyone has their opinion. So here's what's going to happen next. There's 90 days for the appeal to take place, and the Supreme Court has to agree to take the case up. Most people believe that it's likely in light of the circuit splits regarding the Lemon case and the huge impression that it's going to leave on future matters. Is it historical? I'll leave you with that question and that final thought. But a close friend actually pointed out to me that the Ten Commandments stem from Abraham-related religions, meaning Christianity, Islam, Judaism, all have some historical reference to 10 divine rules or 10 divine commandments. So I think that's going to be an interesting way to look at it to see if it is in fact, quote, historical, meaning was it related to something our founding fathers put? I don't see the Ten Commandments anywhere in the Constitution and the Declaration of Independence or in the Bill of Rights. So this is going to be something that we're going to have to grapple with. More to come on whether or not our students have First Amendment rights or whether or not your children are going to be subjected to religious doctrine beliefs hung on the wall in their classrooms. I don't see the Ten Commandments anywhere in the Bill of Rights, the Declaration, or the Constitution, but the Supreme Court will have to explain why Texas got it right or got it wrong. I'm Cathleen Scott. This has been the Cathleen Scott Podcast. We welcome your comments and questions, and I'll do my best to get back to them. If you like what you heard, please feel free to subscribe, and I'll stay on this case and keep you informed. Thank you for joining.